On investment arbitration, again, we'll be hearing about ESG-related damage claims, particularly the relationship between ESG and investment protection, and the role of climate change-related obligations, particularly the Paris Agreement, in investment arbitration. We have again Herfried Wöss, who we are familiar with already from the previous damages introduction to today's panel, and Professor Dr. Nikos Lavranos, who I'd love to briefly introduce. Many of you will be familiar with his work. He's the Secretary General of the European Federation for Investment Law and Arbitration, EFILA as it's abbreviated, as well as founder and owner of NL Investment Consulting, an external legal advisor for numerous law firms. He specializes in not only international investment law and arbitration, but also in topics related to EU law, WTO law, and public international law. And in this capacity has also advised in numerous disputes, of course, also being listed as many of our speakers previously, and bring together additional expertise as arbitrator and mediator with some of the most prominent arbitral institutions. He's a permanent contributor to Kluwer Arbitration Blog, amongst others, and publishes frequently on his research interests. Now, without much further ado, let's jump right in and hear it from Herfried Wöss and Nikos Lavranos. Thank you. You have the floor.
Thanks a lot. We're splitting up our time, and I will start with two main issues. The first one is using the Paris Convention to achieve investment protection. Yeah. And the second one is the question whether investment protection agreement, international investment agreements, an obstacle or a bar to climate change legislation, which seems to be one of these issues related to ECT, which Nikos will further address. So we'll first start very quickly. If we talk about damages, I will recommend you an 8-page document that you may find on the webpage of the UNCITRAL. It's our expert comments. Our is Professor Irmgard Marvo, who wrote a treatise on damages in investment arbitration, calculation of damages. My partner Adriana San Roman, who is also the co-author of our book, and I, we wrote expert comments last year on the note of the UNCITRAL Secretariat on damages, and that note was presented by Professor Don Wallis of the International Law Institute in Washington, D.C. to the UNCITRAL Working Group 3 on ISD. So on that 8 pages, you'll find the hot topics that are that you should be aware of. The second issue is the standard case, Vattenfall, comparison of modern court procedures with investment protection. And that's the evidence that the system does it correct. And in the end, there's some new topics like contributory negligence. But again, the 2 issues, Paris Convention helping, assisting investment protection, and the question whether investment agreements bar climate change legislation. So with respect to your expert comments, you can find them at the webpage. Here's the hyperlink to that. I suggest you read it. With respect to further literature, you see our book on damages in international arbitration, the complex long-term contracts, that does refer to investment arbitration, even if the title indicates it's more for private law. And it also compares 8 different legal rules, 7 countries, CSG, Unitary principles. And in the other book that was co-edited by Nikos Lavranos, we wrote 2 chapters, one on damages in investment treaty arbitration, one on damages in commercial arbitration. I suggest you read it. That's the most updated literature and explains what does Aristotle have to do with the Churchill formula and what was the whole development. Churchill was the product of a historical development in damages. Vattenfall. The Vattenfall case is of utmost importance. The Bundesgerichtshof, the Federal Court of Germany, did not rule on damages with respect to the amount of compensation, but it said there should be damages in a substantial amount. Yeah, so it came to that. I recommend you dig into the case. it's public, and it's very, very interesting because that case developed in parallel with the investment arbitration under the ECT, and both cases came more or less to the same results when you're watching it. So that proves that whether you go to a modern court like the German Constitutional Court, Germany has always been a leader in the development of damages law and influenced basically also Chorzow. Don't forget, factory Chorzow case was a Polish-German case with German judges and Poland somehow sharing also Germanic law. So the hypothetical normal course of events that I already mentioned is found there. So it's interesting to observe how using different modern systems you come to the same result. And that, of course, proves that what is being done currently in investment arbitration with respect to compensation and damages is state of the art. That's not something that has been labeled crippling compensation and other topics. It's basically, well, the state has a right to interfere in property rights and has to compensate for it. Yeah, actually, in France, there are specialized courts for the marché public, public procurement, where the courts do not hesitate to request the state to pay significant compensation and damages for the prerogatory rights of the state, the right of the prince, exorbitant powers that you find in all countries that are based on French law, like in Latin America and North Africa. That's all fine. State can change, interfere in contracts, has to pay compensation. And the courts, and they are very liberal with respect to ordering the payment of compensation. And if you look at statistics, you will find that there's hardly any investment arbitration against France, because their own legal system has a clear-cut principle to not expropriate or do not engage in equivalent acts without compensation. And similar case you find in Germany with Vattenfall. And Vattenfall was settled, both cases, both the investment arbitration and the court case, for 1,425 million. I'm not using the billion because there's a difference in billion in Europe and US. For Vattenfall, 880 million for RWE and some others. So you see substantial compensation in this case accepted. I think the investment arbitration the claim was about 8 billion. Mm-hmm. So next chapter. How do we use the Paris Convention to achieve investment protection? Yeah, there is a current case that has a price ticket of 31 billion. It's not an investment arbitration. It's actually a trade case under Chapter 31 of the US-Mexico-Canada Trade Agreement, the NAFTA 2.0, which has a rather reduced scope for investment arbitration, but still covers energy. And the interesting thing is that being a trade case, and Adolf already engaged in that topic, once you go through all these multiple steps, it's really interesting how many steps they have introduced. I started my career in GATT law and WTO law, working half years there at the legal service of the European Commission. By that time, trade cases had a few steps, and that was it. In the end, you had a panel report with the WTO. It became automatically approved by the parties, and then the main sanction in still is what's called the suspension of benefits. Yeah, for example, in the subsidy cases, Europe puts tariffs on Boeing airplanes in order to compensate in the amount for subsidies that were granted by the US to Boeing and things like that. Now, there are a couple of cases, high technology cases, where that has happened. In times of high inflation like now, even if the US win this case, which is very, very likely, because now we'll see the measures of Mexico, the US will not impose 31 billion tariffs on Mexico, because who would pay the bill? Well, US consumers. So they wouldn't do that. Yeah, doesn't make sense. But they definitely will end up with a declarative, with a panel resolution imposing a large price ticket on Mexico. And that actually might lead to an investment arbitration to follow, because even if it's a trade case, but the topics, energy, overlapping with an investment case. And there was a leading case that Nikos and I mentioned in a seminar on Russia last year, in May last year, the Kanakar case. Yeah, the Kanakar case started with a Chapter 20 trade case that was won by Mexico against the US because the US didn't let in trucks into the US. And then Kanakar, the chamber of the transporters, initiated an investment arbitration against the US that was then settled when the US opened the market for Mexico trucks. So interesting story. I suggest you observe this case. It's a huge case with a rather exorbitant factual situation. So what's the message of Mexico? Yeah? Mexico is the singular country in the world that is actually deliberately destroying renewable energies. Yeah, it does so by, for example, prioritization of dispatch of power generated by plants owned by state energy agency. So the old rules of dispatch of energy was cheap energy first. Yeah, Mexico, as different from Spain, Czechoslovakia, and Italy, did not give any kind of subsidies to renewable energies, and still within 4 years the price dropped to 20% or 25%, and the industry grew like crazy. Where I normally live, which is Mexico, which is a nice suburb of Mexico City, we have the eternal spring. So we have rain season, summer season. It's always every day you have sun. It's always above 20. You can play golf every day. So it's the country for solar energy in the world. So that worked out pretty well until the new government came and said, well, we want monopolies, we want to control the state, we want to go back another 30 years. So first, the state companies dispatches its energy, and then at the very end, you have the renewable ones. So, and apart from that, we don't like the clean energy certificates. So let's include in the clean energy certificates also the atomic power plants, any kind of hydropower plant before 2014. The effect was the next day, $8 billion smashed down because the clean energy certificates that any company has to buy that produces energy lost value. And then the regulating authorities stopped renovating authorizations to auto-consumption suppliers, which is plants that were built in order to supply energy to huge industrial parks and that. And so on and so on. I think there's a list of 40, 50 measures and mainly mainly regulatory agencies not doing their job. So that sounds pretty wild, but that's the reality. And the interesting thing is there is not a single investment arbitration right now. Yeah, all these companies got injunctions through constitutional procedures, and they're sitting through the next 1.5 years hoping that the next government will be of a different sort. So what does the US complain? Inaction, delays, denials, and revocation of private companies to operate in Mexico's energy sector, operation of renewable energy facilities such as wind and solar installations basically stopped, importation of or exportation of electricity and fuel stopped because of the mere resistance of regulatory agencies to provide authorizations, building and operating retail fuel stations, changes of contracts with respect to power purchase agreements by the authorities, postponement of the requirement to supply ultra-low sulfur diesel for Pemex only. So everybody has to sell a higher quality diesel, but the national oil company that can still use highly contaminating diesel, so giving a preference to a state company. And then, of course, there are issues with Mexico's natural gas transportation service that used to be subject to a very sophisticated system administered by a regulatory agency called Senagas, where everybody could buy and sell gas, and now we returned to the monopoly of Pemex. So whatever gas is being sold has to be through Pemex, and that happened within a very short time. Yeah. So how can we use the Paris Convention in case the company wants to commence an investment arbitration because of the apparent measures? The first thing is Article 31.3 of the Vienna Convention, the Law of Treaties, provides that when interpreting a treaty, any relevant rules of international law applicable in the relations between the parties shall be taken into account. Leading cases, Philip Morris versus Uruguay, the tobacco cases, where reference was made to conventions on the reduction of the use of smoking. Some international investment agreements expressly address the relationship between other rules of law, though that is pretty new. If you recall, a couple of years ago, there were the high fructose cases, 3 high fructose cases against Mexico, and Mexico said, well, that's a countermeasure against the US, because the US, they did something wrong in Central America. They gave benefits. They didn't give it to us. It's a countermeasure. And my ex-boss, Professor Peter Jan Kuiper, who used to be high-ranking director at the legal service of the European Commission, and I think he still is a professor for international law in Amsterdam, my first boss many years ago, he wrote an article, and also Sophie Marceau from the WTO and an Australian professor saying, well, it's really bad. I mean, these arbitral tribunals, they think they're in their own subsystem. They don't really care about countermeasures. I mean, they are part of international law. They should take into consideration countermeasures and other rules of customary international law. By that time, nobody cared. Arbitrators thought, well, we apply a BIT, that's it. We don't care of the rest. Things have changed, and time is ripe to consider treaties such as the Paris Convention. And then, of course, you see cases with that refer to the dynamic interpretation of treaties, reference to international public policy. So I will jump over that because the reformed ECT is something Nikos will refer to. But let's check 2 or 3 international investment agreement with respect to the other side, carve-outs regarding health, safety, environment. For example, the USMCA FET shows already something which I addressed in the 2016 article on systemic aspects and the need for codification of international tort law standards. I know that the internationalists don't like investment protection standards to be considered as tort law standard, but from the point of view of damages, the system as such of investment protection is a tort law system. It's very similar to competition law violations, where you have a law, if it's violated, you have the right to damages, both in the US under the Sherman Act or under the EU regimes, where actually private actions for damages for competition law violations are being fostered. And not only that, most of the methods, modern methods of damages calculation and valuation actually were developed in the US under competition or under antitrust law, including econometric methods, such as, for example, the Monte Carlo method that appears from time to time in highly complex oil and gas cases, which is a kind of statistical method. So what do we have here? USMCA FET, minimum standard of treatment. Each party shall accord to covered investments treatment in accordance with customary international law, including fair and equitable treatment and full protection and security. That refers to covered investment. As I mentioned, USMCA has a very reduced scope of investment protection to cover the area, which is construction, energy, and 2 or 3 others. telecommunications. Then the mere fact that the party takes or fails to take an action that may be inconsistent within investors' expectations does not constitute a breach of this article, even if there's loss. So somehow, and we also saw that in CETA already, getting rid of this issue of investors' expectations safe in very precise cases where you can actually prove that there was a commitment. Yeah, and then we have a carve-out provision, Article 14.16, investment in environmental, health, safety, and other regulatory objectives. Nothing in this chapter shall be construed to prevent a party from adopting, maintaining, or enforcing any measure otherwise consistent with this chapter that it considers appropriate to ensure that the investment activity in its territory is undertaken in a manner sensitive to environmental, health, safety, and other regulatory objectives. And what is important, the provisions you see here, they are overlapping. So if you look at the CPTPP or other modern agreements, there have been statistics reported in articles in transnational dispute management where they put percentages, how far these modern treaties overlap, and where the inspiration comes from. So we see developments, even if it's different investment agreements, we see developments that go in the same direction. For example, the non-yet signed EU-Mexico Global Agreement. The first thing is Article 1, right to regulate. Then again, reference to investors' expectation in 14.1. Article 15, you see a case of a modern codification of the FET clause with precise elements such as denial of justice, civil administrative proceeding, fundamental breach of due process, manifest arbitrariness, included targeted discrimination or manifestly wrongful grounds such as gender, race, or religious belief. So you see there's a narrowing down of the scope of FET through codification. Harassment, coercion, or abuse of power, a breach of any additional elements. Again, legitimate expectation limited to specific representation and taking a very restrictive view. The same you find in CPTPP, same kind of regulations. So, what's the issue of the Paris Convention? If you take it into consideration, well, on one hand, in the Mexico case, Mexico transformed, how do you say, special transformation, I think that's the technical term. That means there is a national law in Mexico that copies the Paris Convention that puts for every year a threshold of reduction of emissions. Yeah, so that's the same. The issue is the government doesn't care. Yeah. So you have both the Paris Convention, you have national legislation, and it's just being ignored. Renewable energies are just deliberately destroyed in Mexico. So what is important with the Paris Convention in the context of fair and equitable treatment is what we call the so-called illegality threshold. That's something that has to do with damages, and that's of utmost importance, and I'll show you some examples. You put the illegality threshold up, yeah, you reduce damages, yeah, because it will be very difficult to obtain the illegality. And there is also a tremendous misunderstanding, yeah, regulatory power of the state, whatever. Well, there's always regulatory power of the state, but where does it go? How far does it go in intensity? And when does the illegality start? Yeah, so that's very important. There are two axes. One is the intensity of a measure, basically. If it becomes too intense, it might become illegal. And then you have to determine the point where the measure becomes illegal, and that's the so-called illegality threshold. And that's of utmost importance, because the differential you claim and calculate is when the measure starts becoming illegal to the end of the measure. Yeah, but what was below that was legal, so you cannot charge of that. Now I show you some examples. And the other thing is a temporal axis. Yeah, everything that was before and after cannot be claimed. Yeah. So let's go to the cases. And that has to do with something that is called the but-for premise or differential hypothesis that you find in the factory Joseph case, but different from the opinion of certain authors, mostly partners that work in law firms that only defend states. That wasn't invented in the factory Joseph case in 1927, but actually goes back to Hugo Grotius and even earlier. Yeah, but it's basically the whole damages law, modern damages law, is based on the Nicomachean ethics of Aristotle and the Summa Theologica of Santo Tomas de Aquino. Yeah, and you may read that in our book and in the chapter I mentioned. So you can really trace it back. And in 1855, Professor Friedrich Mommsen in Germany wrote a treatise on the doctrine of interest. And at the same time, there were the first English cases that established basically the but-for premise or the differential hypothesis that says, well, put the injured party in the position it would have been had the breach of contract or the illegal act not occurred. Very simple formula. The practice is a bit more complicated, especially when you have a long-term project. Time complicates damages. Yeah. So what you see in the factory Joseph is basically what you find in comparative law. In our book, we compared 8 different legal orders and we proved factory Joseph is just the result of a development. And as Herr Schlauterbach commented that case in one of his books that we cited, it was just, yeah, they took something over that was already there. So you compare 2 situations, the illegality situation with the legal situation. So if the legal one is, for example, in a leading Ecuador case, 50% tax is legal, 99 is not legal, then you calculate the difference between 50 and 99, but not from 0 to 99. It's not because from 0 to 50 it was legal, from 50 to 99 it was illegal. And what is important, the damages case is a mirror image of the liability case. So keep that in mind. That's of utmost importance. So you really have to define with precision the illegality threshold, because if the tribunal doesn't do it, or the parties, then you come to an absurd result where the damages case is not congruent, doesn't fit to the liability case. So examples of what I mentioned, illegality threshold, is ISA against Spain, where it says, well, the first measures of the Spanish government were legal, were within its regulatory power, but then the respondent crossed the line and violated the obligation to accord fair and equitable treatment at the point in June 2014. Yeah, so where it crossed the line, that's where damages are being counted. Nova Energia, the same. Well, there's a legitimate expectation that there would not be any radical form of fundamental changes. And the first measures did not fall outside the acceptable range of legislative. However, the 4 subsequent measures fell outside the acceptable range of legislative and regulatory behavior, and therefore breached the FET, and for that, damages are being awarded. Of course, we know in Spain, there was then the reasonable damages issue and some new doctrines that appear because, well, somehow, yeah, it was a bad thing to promise this huge amount of subsidies when other countries like Mexico do it for free, you know. Yeah, so there is, of course, a political issue that they say, well, we cannot keep on subsidies that are not reasonable, no? So some of the tribunals found a way out. Good. And the last thing, contributory negligence, yeah, as a way to import obligations such as Paris Convention in order to force investors to adapt to climate change obligations. Yeah? And that has to do with the dissenting opinion of Professor Sanz in Bear Creek Mining Corporations versus Peru, where the investor apparently didn't engage in consultations with local indigenous communities under the ILO Convention 169. There was a causation of social unrest, and Peter Sands argued that there was contributory negligence, though this case was a minimal case of sunk investment. So it's somehow interesting, but there's already at least one article about this case. By the way, there's a new edition of transnational dispute management dedicated precisely to that issue, and one of the articles mentions this opinion, and they say, well, if a company doesn't adjust to climate change obligations, it's actually committing contributory negligence, and that may be a stream of arguments that we will see more often in the future. So I stop here. I hope I was not too quick, and I take over the floor to Nikos Lavranos.
Thank you so much, Herfried, and hello everybody who is still together with us on this Friday afternoon. As Herfried said, I will focus on the ECT, but I want to link it also a little bit to what Adolf has said about the New Zealand EU agreement, because that's quite interesting to contrast those developments, although the starting point for the EU and the member states was essentially the same. And I hope I can share the screen, because I would like to share the ECT agreement. So I will come to that in a minute, because for those, I'm not sure to what extent you are all aware of the developments regarding the ECT. So what happened was that in the last couple of years, we had the so-called ECT modernization process, where in particular the EU and the member states were pushing for the ECT to be reformed and to be aligned to the Paris Agreement, right? Because it was stated that the ECT, coming from the 1990s, wasn't green enough and was an obstacle to the energy transition. Now, what happened was that last year there was an agreement in principle, which is this text that I show you, which was fully agreed by all ECT parties, including the EU and the member states. But then suddenly, over the summer of last year, what happened was that consecutively, several EU member states announced that they would leave the ECT, that they would not sign the ECT, starting with Spain, Netherlands, France, Poland, and a couple of other countries. And Germany, I think, also agreed, at least the German government coalition. So that was quite a shock. And it is quite interesting because we don't know what's going to happen with the ECT, in the sense that last November, it was supposed to be signed off by all contracting parties because they agreed on it. But the EU asked the ECT Secretariat to move this to April this year. So we don't know exactly what's going to happen in April with this treaty. But it's interesting to see, similar like what Adolf has said with the New Zealand agreement, this ECT text, the new one, contains a huge, you can see that pages long, new article 19, which is called now sustainable development. So all the new things that you see here underlined are the new suggestions. So, and when you go through it, you can see that, I have to put this here, that the not only the Paris Agreement, as you can see highlighted in yellow, but also other, and that links more to the previous presentations today, to other CSR obligations such as labor. So you see here the ILO conventions are mentioned as well, are explicitly refer to, and the parties agree to and reconfirm their commitment to implement them. And you can see similar, like in the New Zealand agreement, you see here in paragraph 3 that the parties agree on what we call a non-regression provision, meaning that the parties agree not to lower their standards, right? And you see that the same, even stronger than, particularly with regard to the Paris Agreement. See how long this is, and you see here specific issues with regard to population, biodiversity, land, soil, water, cultural heritage. So a lot of things that were mentioned today are not are in the new ECT, and also very important, explicit mentioning of the OECD guidelines for multilateral enterprises. And as you know, that is the document. Although it is supposedly soft law, we know that through the inclusion in such treaties, and it's also included in CETA and in the other new EU FTA agreements, that through inclusion by reference, they become hard law obligations, and they have to be taken into account by arbitral tribunals when they balance the rights and obligations of the investors and the contracting parties. So this is very, very significant. And you can see then, moving down here, this is the main article here. We have a very specific article on the Paris Agreement, very clearly reaffirming the commitments by the parties to implement the Paris Agreement and also to promote the clean energy transition. And going a bit further, in addition to that, the EU and the member states and the UK also had agreed to phase out the application, the scope of the application of the ECT for fossil fuel investors within the next 10 years. So in other words, after 10 years from now on, if it would be adopted, if it would be ratified, after 10 years, fossil fuel investments would not be covered by the new ECT, by the revised ECT. So effectively, as I wrote also in a couple of contributions to Borderlex and other blogs, this ECT is the greenest and the strongest international investment protection agreement that we have. So it is quite unclear to me, and quite shocking actually, why the EU and the member states suddenly decided to not agree with this a new revised text. And this brings me a little bit to the other aspect, namely how you could have used this provisions when member states, contracting parties, fail to implement the Paris Agreement, right? Because that would have been a wonderful possibility both for investors who see that certain contracting parties to the ECT fail to implement the Paris Agreement, and therefore their investments are negatively impacted. That's number one. And second, we shouldn't forget about that, because we always talk about investor-to-state arbitration, but we still have state-to-state arbitration as well. So this would have been a wonderful tool for contracting parties, such as the EU, such as the EU member states, to bring cases, or at least to threaten to bring cases against the other ECT member states who fail to implement the Paris Agreement, right? From all these perspectives, and I'm stopping now sharing this, it is quite unclear to me why suddenly there has been this campaign, and it should be noted also that the European Parliament also adopted a resolution recently saying that they are calling for the EU member states for what they call a coordinated withdrawal from the ECT. So by all means, we don't know actually at this moment where we will be. So there will be the situation, now it becomes rather complicated. There will be the situation potentially that we have ECT members, non-EU ECT members who are still inside the ECT and actually want to implement the revised ECT. I'm talking, for instance, about Switzerland and the UK, who have explicitly stated that they want to revise the ECT. My understanding is also that Japan, a very important player in the ECT, also wants this. So you have the countries who are in, and then suddenly you have the countries who are out, namely, at least as they say, the EU and the member states. But then you have still the sunset clause, right, of the 20-year sunset clause in the ECT, so which under public international law would be applicable from the moment you terminate the ECT, unless, as the EU proposes, they find a way of an inter se agreement where they would terminate also the sunset clause or call it inapplicable, which is a bit unfair, I would say, for the investors who have relied on the sunset clause. So the ECT is going to be very, very complicated, but zooming back out again to our topic, I think it is very, very unfortunate from my perspective, at least, that the EU is not going to ratify the revised ECT text, because it is in line with, as Adolf said, the New Zealand EU FTA and the other agreements, and it would make the EU a promoter of the implementation of the Paris Agreement, and also, as I mentioned, the OECD guidelines for multinationals, as well as the ILO conventions. So that is one aspect I really wanted to highlight, and I really do hope that maybe the views are going to change in the next couple of weeks. I'm not so sure, especially also because when you look at the statistics, by far 80%, I would say, maybe 90% of all ECT cases so far have been renewable cases, in particular, as you know, against Spain, as Herfried also showed the couple of cases, ISER, Nova Energia, and others. So the ECT clearly is not favoring or protecting in a particular way fossil fuel investments, as is sometimes claimed, but on the contrary, so far at least, has provided an important tool to correct measures adopted by states in such a radical way that they do destroy, and they have destroyed, the investments that they have made, especially the long-term investments in the renewable energy sector, and not only solar, but also wind and some others. So in this regard, not signing the ECT would also leave the renewable energy investors in Europe without a tool anymore, because I think I forgot to mention that, you are all aware of it, but I still mention it nevertheless, is the fact that the European Court of Justice has already declared that intra-EU arbitration is incompatible with EU law. So meaning a German investor could not bring a case against Spain or Italy because of the violation of the ECT. So from that perspective, you take away the protection and the access to international arbitration from, in particular, renewable energy investors, which actually are those that we need most in order to facilitate and actually achieve the energy transition. And not only that, sadly today, as we all know, is the first year anniversary of the invasion, the war by Russia against Ukraine, which has resulted in the energy crisis, but also has resulted in the decision, rightly so, I would say, to decouple from Russian gas and oil. And that means that we need even more investments in the renewable energy, and probably for a transitional period as well in LNG and nuclear power, in order also to achieve the full decoupling from Russian gas and oil, while at the same time ensuring energy supply within the EU for all consumers and all industry sectors. So in that sense, yeah, we have to follow and watch a little bit what is going to happen indeed, actually, in April, when the next ECT meeting is going to take place. But if, as it looks like, the EU and the member states are going to leave the ECT and are not going to sign up to the revised one, I think this would send a terrible message to renewable energy investors, but also to other states in general, that showing that somehow the EU and the member states are not reliable treaty partners anymore. And for sure, I think it doesn't help in enforcing the Paris targets and the Paris Agreement, because it would be so important to have the ECT with all its dispute settlement provisions and all the very strong obligations included in there, that could be used in an effective way. I think I leave it here, unless there are some other questions or comments, maybe also by Herfried or others.
Herfried, did you want to add on to that, or should we move forwards? Generally, in moderating a panel, one should never too lightly handle the luxury of additional time that we now have. Thank you for staying within the time frame.
Just a quick comment. I completely agree with what Nikos said. I mean, he's dealing with that topic very intensely already for quite some time. As I mentioned, I started my career at the Group for Foreign Relations at the Legal Service of the European Commission. Well, by that time, it wasn't even the European Union, it was the European Communities. What I'm always wondering is, where does that come from? Is it the Spanish cases? What happened with this change? Because it doesn't make sense when 80% of the value of European companies, or a significant value, is invested outside of the European Union, just to start crashing down all this protection that these companies has, so your own industry. So do you protect your own jobs? Do you not? And we shall not forget famous, I think it was Jagdish Bhagwati, one of these very famous economists that found that where the philosophical foundation of the World Trade Union, of the World Trade Organization and the GATT before, and he said that, well, treaties in the end to protect populations against their own political leaders. Yeah, as we see right now in Mexico. I mean, we have for 30 years resolving issues, combining local litigation with consultations under the EU agreement, consultations at the WTO in Geneva, and it always worked. I mean, these trade agreements, and in particular investment agreements, are very useful, and often you don't have to go for investment arbitration. You just start with a notice and then very quickly sit on the table, as it happened to us in Peru and other countries, and then you settle the thing and nobody ever talks about it. Everything is confidential. So I just don't get it. What is happening in the European Commission to provoke this brutal change against its own interest, which is the protection of its businesses abroad, and having headquarters outside the European Union, though being Austrian, I just don't get that. In the end, what they're doing is damaging their own industrial base that does foreign investments abroad. So that's my question I have. Where does the whole thing come from? It's just not, I cannot explain it. Thank you.
Alice, did you want to add on directly to that or comment on your panel? So please.
No, I wanted to comment exactly on this, sort of from a funder's point of view. Of course, we are also seeing these developments with great concern, and also with you know, we really don't understand where this is coming from. It makes investment claims that are already difficult to fund because of the duration and enforcement and so on, even more difficult, because with the solar cases, seeing Spain fighting so hard, even if you have, you know, awards there, the risk appetite then for any funder is totally decreasing, which again makes it really difficult for investors to find someone who is assisting them. And here we have this vicious circles. The states or the European Union only see themselves as states, but not as potential host state of investors that might need this protection. And there's another thing that I see with a bit of concern, because of the spillover effect all this might have to commercial arbitration. And I don't we even want to think about it, but I think that the latest things that we have seen and heard from the Commission, I don't really know how commercial arbitration will be affected by all this in the future. And I think we have to be really alert, and if we see any symptoms, try to fight it, because
I totally agree. If I may, on the last point, I've been warning on this already previously many times. I think I come really, or I've stayed so far mainly in the investment treaty space, but we were sleeping. We were sleeping, literally, and we didn't. And back in the time, and I'm talking about 2010, 11, when the TTIP negotiations suddenly became a bit more public, right? We were sleeping. We couldn't imagine, in particular through the NGO pressure and the social media pressure, we couldn't imagine what a snowball effect that had, right? It was a new, and Herfried remembers that, a new battle in Seattle. That is what happened, and we didn't see the signs. So I totally agree. And I mean, so far, for what it is worth, when we read the PL Holdings judgment from the European Court of Justice, we can see that it still tries to carve out commercial arbitration, right? It doesn't throw it together in the ACMEA and the Comstroy bag, in the sense of saying, okay, it's all forbidden, but I totally agree with you. We must be very vigilant and we must push back right from the beginning, and we must stress really the importance of commercial arbitration. I think that's absolutely essential that we do that, especially because we now, at the European Commission itself and the European Court itself, have now acknowledged that in several EU member states, there is a rule of law backsliding. You cannot deny it anymore. I have written about that as well, a very long article on this 2 years ago. But now we know it from the European Court, we know it from the European Commission, that the backsliding in the domestic courts, which is the only thing that is open now within the EU, is there. We know it from Poland, Hungary, and there are some other countries as well. So I think commercial arbitration is very, very important. And that answers a little bit also to Herfried's point. I think it all feeds in this framing that we failed to correct in the beginning, that somehow ISDS is pro-investor biased, which when you take any number is wrong. When you look at the UNCTAD numbers, we know states continue to win more cases, always, right? We know, for instance, with the what you also said with enforcement, I can send this in the chat. I recently published a study, which is going to be an annual study, which showed that, for instance, Spain hasn't paid any solar award yet. It's fighting all the time until the very, very end. So there is also the bad signal that states give, that even if there is a treaty, you are not even sure that the state will actually fulfill its commitment under the Exit Convention or the New York Convention to actually pay the award, right? So this is another aspect we have to take into account. But I think, yeah, there is the problem that to a large extent, NGOs and certain parties in a certain spectrum have taken over and have framed the debate very much in the sense that, and you can see that, I mean, there are titles like in Politico, where they talk about the dirty ICT, right? As if the Energy Charter Treaty is somehow, you know, protecting fossil fuels in a particular way or whatever. So the framing is very important, and we have to be very vigilant to do this. And this, I think, is also very good that we have this webinar, that we clearly state this, how important it is. And like Herfried said, it's also about jobs, and it's also about R&D, right? Because we need also investments in new energy sources that are out there, right? That need to be developed, and yeah, we have to be careful.
Thank you so much. This has turned out now towards the end of our long panel to be quite an exciting conversation, triggering also responses from within the panel. Thank you so much.